Okay, thank you. Justice Thomas? Justice Alito?
Well, let me begin with Justice Sotomayor's rebuttal of what she took me to be asking about regarding constitutional rights. Now, she will have the right to say rebuttal, which I won't have a chance to answer under this questioning regime that we have now. The Fourth Circuit test, which you seem to agree with, as I understand it, was any important constitutional right. So that wouldn't be limited to sentencing errors, would it? It would encompass all of the things I was asking about before.
No, we're just talking about the appellate right on the sentence.
Okay, we're just talking about
Yeah,
sentencing.
that's all. Every circuit, the whole circuit split is about when you can appeal sentences. So as Justice Jackson said, these are all things you wouldn't.
So anything that wasn't known prior
at
to
sentencing,
the time of sentencing. Again,
I tried to say with Justice Gorsuch, it has to be clear. So when you have an unconstitutional right to not go to church, it seems ridiculous that a lawyer would say, by the way, you're sentencing this, I know you're religious, so there might be a chance that supervised release, he's going to think you're a religious fanatic and say, don't go to church. And all we're saying is, come on.
Okay, what if it's a sentencing issue that was known by the parties before entering into the plea?
Yeah, so all of that would be factored into any contract offense. It would be factored into miscarriage of justice. That's why guidelines are all out, is because it's known at the time of sentencing that, you could be sentenced up to the statutory maximum. It really doesn't matter what the guidelines say.
What about guidelines issues during the period when compliance with the guidelines was mandatory?
Oh, I think that would have been now you're taking me back to
sentencing error.
Yeah, you're taking me back to pre-Booker. So, no, I don't.
No?
I don't think so. Sentencing guidelines is just something that happened. Now we could talk.
It was above the statutory maximum because the statutory maximum was defined by the mandatory guidelines.
Yeah, and we could talk about that, but we don't need to because it's advisory, and all courts have said sentencing errors are out. And if you write this opinion, you can say that too. So that way you just.
What if the guidelines call for a sentence of 6 months imprisonment, but the judge says that's woefully inadequate, and anyway they're not mandatory?
30 years.
Right.
Maximum. Some of you could leave open a miscarriage of justice, but I just wouldn't because courts have just said they don't want to see sentencing errors. But yes, sure. If you want to say they so misapplied the criminal, whatever it's called, the criminal career offender one, where you get this massive bump. Courts really don't want to see those. They just want, look, up to the statutory maximum, guideline errors are out.
Okay, one final question. If we're, well, maybe not the final one, but if we're going to apply contract law, what body of contract law do we look to? It's not the same everywhere.
Yeah, you look to the same that you would look every time you apply contract law, including in Rummery. You look to the restatements, you look to centuries of case law.
We look to the restatements?
That's what you did in Rummery. You cited restatements 171, and that's what all the courts have done. I mean, you have, the court held, will apply, general common law to how contracts. But you have so many cases implying collective bargaining agreements. We cite a lot of cases in the brief where you're applying contract law. Remember, the government is always applying contract law. I don't know whether they're citing the state that they're in or they're citing the, I don't think the cases really care. All contract defenses are so narrowly circumscribed that, and the Court of Appeals, if 34 years, not even a trickle, much less a flood, a river.
Thank you.